Well, good afternoon, Michiganders. It is Tuesday, March 7th, 2023, and of course, this is Tuesday with Tom, Michigan's only weekly podcast where we do answer your questions about estate planning and estate settlement in Michigan, and we don't send you a bill. As always, I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, an ambassador for all things good in this great state of Michigan. Welcome to today's program. Well, just a brief recap. Last episode talked about Roth IRAs and making sure that you understand the Roth IRA 5-year rule. So if you have a Roth IRA and you're interested in knowing about the tax implications of that Roth IRA, particularly distributions, because you might be surprised to find that all distributions from your Roth IRA aren't necessarily tax-free, please listen to last week's episode. Today's episode, it's March. March Madness is here. Springtime is coming. And so today's show is all about it's time to spring clean your estate plan. But please remember that what I'm about to discuss during the program is, as always, for educational purposes only. It is not intended to be legal advice. You need to work with your attorney to determine what is appropriate for you and your estate plan. It's time to spring clean your estate plan. As spring arrives, the weather gets better. Many of us are starting to think about being outdoors, working in our yards, cleaning up after the winter, getting things ready, getting our lawns ready, getting our flower beds ready, all of that spring cleaning that we do outdoors on our lawns. And many of us will be doing the same thing with our homes. They've been closed up all winter, haven't had much opportunity for fresh air to be in our houses. So we start throwing open the windows and start going through and giving the home the once over as part of an annual spring cleaning ritual. Well, the same thing applies to your estate plan. Did you know the number one mistake that people make after creating their estate plan, this is after, not before, but the number one mistake that people make after creating their estate plan is failing to keep it up to date. They prepare their plan, they might stick it away in a safe deposit box or stick it away in a drawer or a safe in their home, and they don't look at it for years and years and years. I recently had clients come to see me, brought with them their current estate plan. Their estate plan that they brought into me, their wills that they brought into me, were created in 1954, the year I was actually born. So that will, or those wills that they had created for them in 1954, were still their wills to date. Now, obviously, in reviewing it with them, many things had changed in the meantime. Who they wanted their estate to go to had changed. Who they wanted to be in charge of things had changed. Their financial situation has changed. Their family situation has changed. But that will that each of those clients had from 1954 is still their will. So what you should do is at least annually, in tax time, I tell clients all the time, you're looking at your finances, you're looking at your taxes, it's springtime. Annually, in the spring, you should pull out your estate planning documents and look them all over. Why? Because things change. Number one, the laws have changed. Let me just go through briefly a number of those laws that have changed over the years. In 2005, HIPAA laws came into place. We're all familiar with HIPAA laws. medical privacy issues, and HIPAA laws can impact your estate plan if it was prepared before 2005 and you don't have appropriate HIPAA language contained within your trust, contained within your powers of attorney, etc. So 2005 HIPAA laws came into being. 2012, and I've talked about this again in previous episodes of this program, durable power of attorney laws changed in the state of Michigan. As of October 1st, 2012, durable powers of attorney in the state of Michigan now statutorily are required to have a section that's called an acknowledgement of responsibilities. That is a place where the people that you have named in your durable power of attorney have to sign the document acknowledging what the limitations are on their authorities and acknowledging that they accept the appointment and those limitations. So if you've got durable powers of attorney that are out there that exist from before 2012, you need to make sure that you get those durable powers of attorney updated so that the people that you have named in them are going to be able to carry out your wishes. Federal estate tax. Federal estate tax has changed significantly over the years. Currently, the federal estate gift and estate tax exemption amount is now $13 million, which means what? If you die in 2023 and you don't have an estate larger than $13 million, you don't have to worry about that 40% federal estate tax rate. But your plan that was drafted back when the federal estate tax exemption were significantly left might not be appropriately drafted to account for the fact that the federal estate tax exemption has risen over the years. So even though you don't have a federal estate tax problem, if your trust in particular was created years ago in consideration of what was the then federal estate tax exemption, it might be totally inappropriate in light of the increased federal estate tax exemption today. Annual gift tax exemption. If I asked anybody today, how much can you give away to somebody annually without worrying about a gift tax, most people are going to tell me $10,000. That number in 2023 has finally escalated over the years to $17,000. So that can be important in looking at your estate plan if part of that included gifting and using up the annual gift exemption amounts. $17,000 is the current number. And the other significant change in the federal estate tax area that occurred over the last dozen years or so is the concept of portability. Portability meaning what? If I die, or when I die, I do not have an estate that uses up my entire estate tax exemption, I can pass that unused portion of my exemption on to my spouse. Now, that is not automatic. There has to be a federal estate tax return filed for me and making an election to convey that on to my spouse. But it is a change, and it can impact a number of estate plans that were drafted out there before portability was available to us. Another change, 2016 now. In 2016, we had the ability to appoint a funeral representative. Before 2016, you did not have any authority to decide who was going to make your funeral arrangements for you. The statutes in the state of Michigan determined that for you. Since 2016, you have the ability to decide who it is that you would want to make those funeral arrangements for you. And that would be in a document that, at least when we prepare it, is called an appointment of funeral representative. So if you don't have one of those, you have the ability to incorporate that into your estate plan. Another thing that has occurred since 2016 or thereabouts is many financial institutions, unless a trust or unless a will specifically authorizes your trustee or your personal representative to engage in electronic banking, they don't allow it. So the idea is that your documents need to be sure that they are updated to authorize your trustee, to authorize your personal representative to engage in electronic banking and to manage your digital assets. That's a big one today, digital assets. Emails, online bank accounts, online music services, etc. All these different assets that are digital that we have today, there are provisions under Michigan law now for granting access to your representative to access your digital assets so that they can be properly addressed in settling your estate plan. In the area of Medicaid, we have Michigan's Medicaid recovery law that came back in a number of years ago now, but many estate plans aren't designed today to account for that. Essentially, the Medicaid recovery law, again, and I've had other episodes in the program, Medicaid recovery law says to the state of Michigan that when somebody is on Medicaid and they die, the state of Michigan is supposed to try and recover from their estate what the state of Michigan paid for them to be in that nursing home. So Medicaid recovery law can be an important consideration, and in particular, what are your options for avoiding the Medicaid recovery law so that at the time of your death, your estate doesn't go to the state of Michigan in order to repay the expense related to your long-term care. And going along with that Medicaid recovery law, a type of deed that's frequently being prepared today is what lawyers call a ladybird deed. A ladybird deed essentially is it's still your home, but it transfers automatically at the time of your death. Ladybird deeds are being incorporated in many estate plans today for a number of purposes, including protecting assets relative for married people. Married people who own their real estate in the state of Michigan have unique protection from creditors, and that can be protected with a ladybird deed. It is a strategy that's oftentimes used in conjunction with that Medicaid recovery law as well. Big one that's occurred over the last several years is same-sex marriage. Same-sex marriage, not necessarily all of the laws in Michigan have yet caught up with it. I know they're working on it, trying to get everything caught up with it. But if you have a same-sex marriage, you need to look and see what options do you now have that perhaps you did not have available before. How does that impact whatever estate plan you had done before? Another big one is dower in Michigan. We used to have dower rights, or women had dower rights in Michigan, where their husband, if they owned any real estate, the spouse had a legal interest in that real estate. We do not have dower in Michigan, and that's dramatically changed women's rights relative to their spouse's property. Another one, Uniform Transfers to Minors Act. If you have a minor, maybe a child, maybe a grandchild, and you're incorporating them as part of your estate plan, you now have the ability to have a Uniform Transfers to Minors Act. It's an account that you can set up where funds or any assets, quite frankly, can be set aside to be managed for the minor until they turn 21. Without that, you might be dealing with a probate court, guardianship and conservatorship. Conservatorship's going to end at 18. So if you want to tie it up a little bit longer without utilizing a living trust to do that, a Uniform Transfers to Minors Act might be appropriate for you. Again, all of these things that I've just kind of summarized here are different topics that I have addressed in previous podcasts. So if you have questions about any of them in more detail, simply utilize the search feature on the Tuesday with Tom website. But a number of laws have changed over the years that could impact your estate plan if it hasn't been updated. Another one most recently is the Secure Act. That has to do with distributions under IRAs and the time for distributions. Essentially, they have eliminated the idea of taking a beneficiary, the ability of them to stretch and take the IRA that they're a beneficiary on out over the life expectancy. There's now normally a 10-year limit on that, and that can dramatically impact somebody's estate planning as well. So laws have changed. What else could have changed, though? Well, what else could have changed is your family could have changed. Maybe you've had more children or you've had grandchildren. So the individuals, the people that you're interested in leaving your estate to, have increased. Or maybe a son or a daughter has married or divorced. That can impact the decisions that you made relative to your estate plan. Certainly deaths of the individuals, either those people that your estate is supposed to go to under your documents or those people that you've named in your documents for the different jobs that they might have. Maybe you've got somebody named as a successor trustee who has died, or maybe they were named as your power of attorney and they've died. So deaths of individuals that you have incorporated in your estate plan need to be looked at. Certainly health issues can arise. Maybe you've got some dementia going on in your family or a serious illness going on in your family, but all of these different family type changes. Again, look at those clients that came in the other day to me, 1954, a lot has changed just in their family. Set aside all the legal issues that I've talked about. Much has changed just within their own family, so they need to make sure that their plan is current. And of course, retirement can impact. Maybe you've now retired, or maybe your spouse is retired, or maybe individuals that you had incorporated into your estate plan have retired, and that might affect your decisions that you made about the estate plan that you had. So family changes oftentimes necessitate changes to your estate plan. Another area are assets, what you own, right? Maybe you've sold that home that you owned 10, 15 years ago, bought a new house. I can't tell you how many times it happened to me. The client has said to me, "Hey, Tom, did I tell you that I bought a new house?" Answer, "No, you didn't." Well, we need to know that if you in particular have that home as part of your estate plan, frequently it might be as part of your revocable living trust, you need to make sure that appropriate deed work is in place to address that new home, whereas the old home, you don't have it anymore. Or maybe you purchase new life insurance. Well, who are the beneficiaries on the life insurance policy? What's going to happen with the old life insurance that you no longer have? Sometimes clients in their estate plan documents refer to a specific life insurance policy, and if they don't have that policy anymore, they need to make sure their documents are appropriately changed to reflect the new policy. Or perhaps you have new investments. You might have new IRAs, new 401ks. You might have new stock portfolios, bond portfolios, CDs, all of those kinds of things that you have by way of assets. Cars, motorcycles, boats, all of these different assets can change over time, and you need to make sure that your estate plan as needed changes as well. You might also have changed your mind about your estate planning goals, who it is that you want to receive your property. That might have changed over time. Maybe you had a child back a long time ago that you had a falling out with, and maybe you've now reestablished that relationship, but you excluded them from your estate plan before. Now you'd perhaps want to include, well, that needs to be accomplished by having your estate plan done. Who's going to make medical decisions for you? If you've got a power of attorney for healthcare or a patient advocate, that might have changed over time. I had a case not that long ago with a couple sisters. They had named a nephew as their healthcare agent. One of the sisters had some significant medical issues. the other sister saw how the nephew handled that and taking care of what would have been the aunt, wasn't happy with how that nephew took care of things, so she wanted to make changes to her documents to appoint somebody else. So again, who's going to make medical decisions for you? That might have changed. Who's going to manage your property? Who's going to settle your estate? If you have a trust, who's going to be your trustee? Who's going to be your personal representative? All of those things can change over time, and you need to make sure that your plan is updated to address those changes that have occurred. And it's simply your goals, what's important to you, might have changed. What are your estate planning goals? Maybe before it didn't matter that your estate went through probate. Perhaps you didn't own a lot. Now perhaps your estate is much bigger or your family circumstances are much different. And your goals for your estate plan, maybe now you want to look at avoiding probate, or perhaps before you were avoiding it, and maybe it doesn't matter to you now. But your estate planning goals also oftentimes change and develop over time, as well as your investment goals. So all of these things change over time. And so what you should do, don't wait 20, 30, 40 years before you make these changes, because if you die in the meantime, what you already have in place is going to control where your estate is going. So we recommend annually, tax time, spring cleaning time, that it is time to spring clean your estate plan. And of course, Amanda and I would be honored to have the opportunity to help you with your spring cleaning relative to your estate plan. Perhaps it's looking at amending a plan that you've already done, meeting with you, discussing the changes that have occurred in the law, looking at the change of your circumstances and how do we incorporate all of that into the estate plan that you already have. Or maybe you don't have an estate plan, and we certainly can assist you in putting your plan together and creating the documents that will implement that plan for you. Or, of course, we are here to assist you in settling a loved one's estate. Now, you've got some options. We are back to having, on a limited basis, in-person consultations at the new East Lansing office. And we still have our virtual consultations via Zoom or telephone. Either one of those, or one of those in-person or virtual consultations, can all be arranged. Simply visit the website, which is doylawpc.com. There you will find information on how consultations can be scheduled, again, in-person or virtual consultations. Reminder too, if all you're looking for is an individual document, perhaps all you need is a new healthcare power of attorney, or you need maybe a certificate of trust as part of settling estate, simply visit the legal store. Again, that's available at doylawpc.com, where you have the ability to order individual documents. And if you're a current client of ours, there is the opportunity to process what we call our Update My Plan request, again, available through the virtual office at the website. That would be some where you're looking and saying, hey, I want to make change. I want to change this person in my plan. We'll review it, determine what documents need to be changed in order to accomplish all of that for you. So we give you a number of options in scheduling consultations with us and providing legal documents to you. Again, all of that's available at doylawpc.com. Well, that's going to be it for today's show. As always, though, if you have a comment about the program, a topic that you would like to have me discuss. And many of the topics that I've discussed over the last several years have come about from people asking me to talk about a particular topic, or perhaps a question that you'd like to have answered. Again, many of the previous episodes have come about as a result of questions that clients have about estate planning or estate settlement. So if you have a topic you'd like to have me discuss, questions that you'd like to have answered, please send me an email, tom@tuesdaywithtom.com. And as always, please follow us on Facebook and invite your friend and family to follow us as well. That would be Tuesday with Tom. Follow the office as well on on Facebook. That would be Doyle Law PC. And just a side note, we're still not actively utilizing Twitter for a number of reasons. So don't look for us to be posting things on Twitter. Facebook is going to be the social media platform that we're using at this point in time. Of course, too, the program is available probably wherever it is that you listen to a podcast, be that Apple Podcast, Spotify, Google Podcast, iHeartRadio, Spreaker, Ask Your Smart Speaker to play Tuesday with Tom. So many distribution channels where you will find this program available for your listening. Well, thank you again for spending some of your time with us today. And as always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.